Joining us today is Megan Smith. Megan Smith's a great practitioner here in the area of Sacramento. I've had the occasion to meet with her before and break bread, so to speak. And so she's very pleasant, easy to talk to. So if you have people that have questions to ask and they're afraid of going to the big bad lawyer's office, Megan's the one for you. You give Megan a call and she'll be able to sit down and answer any questions that you have. And if you have loved ones that might need a little bit more hand holding than they're going to get at the law firm of Abercrombie and Fitch. Wait a second. That's not a law firm. That's a clothing store. But you get the idea. These big Brooks brother wearing suits. This is going to be a way for you to get questions answered. Maybe we'll answer some of them just in this series of videos right here. But this is a great opportunity. Megan was in the Navy just like I was. We both were in the Navy, although I think she carried a little more jewelry on her shoulders than I did.
Not much, the bare minimum, but yes.
And then after that, she was a UC Davis Aggie, or was that before that?
Twice before. Yes. So I went to Davis for undergrad and for law school, and then joined the Navy out of law school.
Boy, that was a high bar. UC Davis has a great law school program, and they're very well respected and sought after. And you've been hanging your own shingle for quite some time, right?
Sure. Yeah. Started that about 2016 and have been going strong ever since. Estate planning, probate, and trust administration is all that we do here. That's it.
Awesome. So tell me if you will, what is one thing that, and we didn't really prep these questions, so she takes a second to get it done. Don't sweat it. But what is one thing that really surprised you after you got into actually practicing? So, I mean, you have the ideas of what law is and what estate law will be. What's something that actually surprised you once you got into it?
As a brand new lawyer, what really surprises you is the extent to which you immediately have the cloak of authority. You are expected to know everything about everything right off the bat. And the lesson you take away from that as a young lawyer is that you need to grant yourself the grace to say, I'm going to go ahead and look that up because I don't have the answer, because getting it right is far more important than getting it fast.
Oh, that is great. That is a great lesson to learn. That's for sure. And I'm amazed that's really similar to when you're starting out in sales as well. It's so much, anytime I guess you're representing the interest of another.
Yes.
If you're representing, if you want to get it fast, that's great. If it's yours, if it's you're getting the answer for yourself. Right. But if you're getting the answer for somebody else in sales or in law practice, it's probably best to go ahead and get the right answer instead of just the quick one. So one of the things that estate law does, and where estate law and real estate law, there's a lot of areas that they interconnect, but one of them is obviously this area of, do I need to put my home in a trust? And so let's just bring that one up right out of the gate. Sure. I have heard it said through the grapevines, on the internet lawyer, right? Just like the internet doctors have said that everyone that owns a home in the state of California should probably have their home in a trust. Would you agree with that?
I'd be hard pressed to think of an exception. Yes, I would almost unilaterally, I would agree with that. There are rare exceptions, but those would be personal circumstances. If you own real estate in California, you have the net worth to trigger a probate. And if you're going to trigger a probate, your house should be in a trust.
Talk to us a little bit about that. What is this dreaded probate that everybody wants to stay away from?
It's not true in every state, but in California, we have created a probate process that is expensive and sometimes a bit onerous. So probate is the process that is court supervised, by which we decide what happens to property after someone has passed away. So it's the process of determining, did they leave a valid will? If they didn't leave a will, or their will is in question, who are their natural heirs? Who would the state decide their property belongs to? So this is overseen by a judge. Generally, the family or the executor is represented by an attorney. And the process is, let's figure out what this person who has passed away owned, who's entitled to receive it now, notify all the creditors that this person has died, and then wait and sit and wait, sometimes for several months, for the process to run its course. Probates can run a year, 14 months, 16 months, sometimes even much longer than that.
And hold on a second. So the people that it's being left to would have to wait until the probate settled out, and that could take as long as a year or more.
It can definitely take a year or more. There are ways in which you can get earlier distributions of some amount of property if the family needs it. but again, it's overseen by the court. It's the process of determining, did you leave a good will? And if you didn't, who are your heirs? When you create a trust, what you do is you decide in advance what should happen to your property after you die. And then you don't, in most circumstances, need a court's intervention at all. So it is much faster. And most importantly, while speed is good, most importantly, it's just a ton cheaper. You know, it doesn't have to be a difficult process, the probate process, but it is time consuming, it's expensive, it's onerous for the person who often volunteers to be the executor. And for the privilege, you spend many months reporting back to your attorney and providing information and responding to requests. And ultimately, when it's all said and done, getting access to something that could have been left to you in a trust without any of that difficulty.
Wow. So you mentioned costs. So tell me, what is I know these lawyers are all driving Lamborghinis and, Ferraris and things like that. So how many tires am I going to have to buy their Lamborghini in order to get a trust done?
The cost of a trust is based directly on how complex the trust is. So let's talk a little bit about what trusts can do for you. First thing that most people are looking for is the ability to avoid probate. So they want to say, when I die, I want this asset that I own to transfer to my children.
But isn't that what a will does?
A will does that. What a will does, though, is it transfers it to the children after the court has reviewed the will, agreed with its validity, and paid all the lawyers and the creditors. A trust says, when I die, I want my property to go directly to this named or named individuals, multiple people, and you do it with the permission of the trustee and no court oversight. So
wow.
a trust is that conveyance vehicle, but it also can be a lot more. And this is where complexity in trusts can come into play. Sometimes it is appropriate to control the inheritance of a person after your own death. So this is often most appropriate. Imagine you have young kids and, a family will come to me and say, I want to make sure that there are guardians appointed for my children. And I want to make sure that if I pass away, my assets are invested for them. They have money for college. Somebody can pay for their wedding, that those assets are available for them. It's not always the best idea to give an 18-year-old child a check for 6 figures, 7 figures. That's not always the best plan for long-term financial success.
That's right.
So a trust can control that money, manage it, keep it invested after the unexpected death of a parent, make sure that money makes it through life's milestones without getting blown on Lamborghinis, for instance. And when you build a trust like that, you are building an entity, a thing that's going to live into the future. So that's a little bit more complex than the type of trust I might build for someone who's, say, 65 and owns some real estate and just wants to make sure their kids don't have to go through probate.
Right. So let's say one is a simple trust and the other one may be like a legacy trust or something like that. Or do they have names besides the ones I just made up?
A legacy trust is a general concept. Legacy trust would be considered something that is designed to preserve family wealth from generation to generation. So that would be the type of trust where not only are we trying to keep kids from buying Lamborghinis, but we're also trying to keep kids who are then later adults and potentially elderly people themselves. We're trying to keep them from losing the family legacy through creditors, through divorces, through other things that can erode a family's multi-generational wealth over time. That type of complex or legacy trust exercises control, potentially multiple generations into the future.
So we've got an A, B, and C category. C being you've got a lot of wealth and you're trying to do generational planning. B is just you're trying to take care of your kids and make sure they don't get the money too quick. And A is pretty simple, probably used with adult kids and things like that. So is that A plan, is that a simple trust? You got a house, maybe a couple of bank accounts and stuff, that kind of smaller plan. Is that $20,000, $30,000, $40,000 or what would normally, I know you can't be exact, but what would a normal trust cost?
Well, more, each firm offers a different set of services to their clients. Each firm offers, a different level of engagement. Those types of trust, though, for when you're talking an individual or joint trust for a family where we're not exercising a lot of control, those types of trusts are generally going to be in the lower four figures. So you can expect to pay in the range of $2,000, $3,000, $4,000, $5,000, something like that for a trust of that nature. And these numbers always change. And again,
let's flip that to a probate. Sorry to interrupt.
Sure,
you.
Of course.
What's a typical probate with a house and a couple items? What is a typical probate that might be equivalent to that cost?
Here's the rub. Probates in California are the attorneys are paid based on a statutory scale. And so that means that it's set in the law how much the maximum, I should say, that attorneys are allowed to charge for a probate. The fees for probates for the attorneys are based on the value of the assets that move through the probate. So what that means is attorneys make a percentage on those probates.
Good with that so far.
So far, right? However,
being a real estate agent, I'm okay with percentages.
It's great. And, attorneys in California make a lot of money on probates.
Do they?
I could write a trust that we talked about with a family that has, let's say their home is worth $600,000. Let's say they have a $350,000 mortgage on that property, $400,000 mortgage. They have a couple of bank accounts worth a few $100,000 each, investment accounts. If that person passes away and their estate is worth, let's say $800,000 before the creditors are paid, the probate attorney is going to make a piece of that $800,000, regardless of the total net value of the estate. And the cost to administer that estate just on the attorney's side is going to be about $20,000.
Whoa, hold on a second. So you're saying if their house is worth $600,000 and they owe $550,000, they're not going to be, it's not $50,000, it's the whole 600.
Correct. Yep.
Wow, now I don't like percentages anymore. so
it's a substantial, it can be a very substantial chunk. And I mean, honestly, if you own real estate in this area, let's say you own it is very, very easy for the gross value of your assets to exceed $1, $2, $3 million. And most of that is either mortgaged or in equity. I mean, obviously, and some people much more than that. But you can end up owing substantial probate fees for a probate for an estate that is largely leveraged. And a trust removes all of that uncertainty from the picture.
We tell stories. I like to tell stories that are real people, right? And so the names of this story don't apply, but I recently did have someone who inherited a property from their dad, and we're just going to call him Mr. Orange. And so Mr. Orange left his son this property, and it was the same situation. By the time they got done, they actually had this property that was in their name, but had no value. And it also needed to be fixed up a lot. But because the probate fees were there, it just really caused them a lot of problems. And that really could have been solved with simply having a trust. And so that was a big deal. They could have made money on the transaction,
right?
A little bit of money, but that little bit meant a lot to them. And they could have made some money, and instead it was a situation where they really couldn't be helped. It was like, you know what, you're easier just to give it to the lender, because it's just not going to it's not going to do you any good.
Yeah, absolutely.
So I'm going to get a little more specific with this one.
Sure.
I have someone who is getting ready to pass. He's 86 years old or so, and he's married, and him and his wife have a condo that they've been renting out. And they aren't able to sell it through the normal channels because of some stuff that's going on with the condo association, and that no one can get financing on it, red tagged with the city, that kind of thing. So we now have him set up to do a seller carry. And so the seller is going to carry a note, right? Can that note be placed into the trust? So the seller is going to seller finance the property. And so he's got $100,000 coming in as a down payment, and then he'll carry $200,000.
Sure.
So the answer.
So yes, absolutely. A trust can own really anything that an individual owns. Things that we commonly transfer. We talk a lot about real estate because that's very common. It's very understandable. People can relate to it. But the other things that we transfer into trusts, which is called the trust funding process, you might hear the phrase trust fund and think of something entirely different.
Right.
But
I've
the
got one of those.
process of funding a trust, moving your property into a trust, it involves determining what does the person who's creating the trust own, and will they benefit from moving it into this trust structure. So we commonly assign things like mortgage notes, intellectual property, business interests. All of those types of things can go into a trust. Intangible personal property, as I mentioned, like copyrights and things like that. All of those can be assigned to a trust. The goal is when a person, if your goal is probate avoidance, the goal is that when the individual actually passes, they have already gifted all of their assets to this trust, and they, from the court's perspective, die without anything. So they've already gifted it away to this estate. And the estate then, it basically jumps over the veil, if you want to look at it that way, and arrives on the other side of that person's passing without the need for a court order to transfer those assets.
Right. Got it. That's a good way of putting it. Helps me understand it. Within that trust, so they've got these items within the trust. They can control, if they have 3 kids, they could say the total value of the trust goes to these 3, 33, 33, 33, or they could even say this item, or so anything you could do in the will, you can do in the trust, right?
Definitely.
Okay. So that makes sense. Let me ask you another question. We've spent a lot of time talking about trust. I know that you do a lot of different law. If someone was referring a client to you, what are some other areas that you think, most everybody should be looking at as far as estate planning? What are some areas outside of just controlling their real estate when they pass?
People come to me looking because number one, they want to avoid probate. Number two, they want to look out for minor kids. Those are the 2 things that drive most clients who contact me. But it's my job to also look out for what else can an estate plan do for you. And a good estate plan, and this is where a will really falls down on the job, even if we want to pay for a probate. What a good estate plan does for you is it provides a series of tools, mechanisms, through which your family and friends and others can protect you if you are living but incapacitated. It is extremely common. In fact, nearly everyone who is in a marriage, let's say, or a relationship at the end of life, eventually one person will be what we call the surviving spouse. So the redundancies of marriage have fallen away, or you've been single for a time and there's no safety net for knowing that you're potentially becoming incapacitated, dealing with a dementia diagnosis, dealing with a physical illness. One of the nice things about a good estate plan is that it includes incapacity planning. And that generically refers to the fact that a trust can be managed for you while you are living but incapacitated. It also includes great documents like a really robust power of attorney that lets someone else make legal decisions for you if you're living but can't make them for yourself. And of course, lastly, we always include healthcare documents as well, so that you can name 1 or 2 or more agents who can make medical decisions for you if you're not able to make them for yourself.
It is kind of funny, and I stand here as a, let's just say 280 plus pounds, right? I stand here as a man who is not in great health, but it is very funny how well we delude ourselves that the thing that happens to everyone 100% of the time,
yes,
that we all die, every one of us do, at least as far as so far, everyone has died except maybe one came back.
With rare exception, the exception that proves the rule. Yes.
Yeah.
Absolutely.
So, but for the most part, we all almost don't want to even talk about it. We don't want to plan for it. Yet it's the one thing that we actually share in common. And many other things we don't share in common, but we spend a lot of time thinking about them and planning for them on vacation, or planning for this, that, and the other, talking about cars or all this stuff that we share a little bit in common. We share it in common with some people. But this item we share in common with everyone.
Oh, yeah.
And we don't actually plan for it, and we wind up suffering the causes. I think of my wife is a big fan of Prince, or was years ago, and how he passed. And basically nobody he loved. There had to be somebody he loved, and nobody he loved got to benefit from his estate, within reason in the time period that was allowed. Definitely stuff happened with his music that he didn't want to have happen to his music. He never wanted to be in an Arby's commercial. That was not his dream.
Sure.
And so we all face that. So I really appreciate you taking the time to
Absolutely.
to help us with this. And then if somebody's going to send you a client, what's the best way for them to do that?
Oh, definitely just right through my website.
Okay.
I've all the contact information is there, information about our specialties, and a contact form to request a consultation. So you can find me at smithestatelaw.com.
Awesome.
Anytime. Yeah, reach out. And that's, we offer consultations by phone, by Zoom at people's preference. So we're here to just kind of, demystify it, make it not so scary. And, I've had a surprising number of clients say, that was actually kind of fun. And if nothing else, it's a huge relief to have a massive to-do off your list. I have clients that said, this has been at the top of my to-do list for 30 years. I said, well,
right.
No time like the present, right?
And that is so true. I'm somebody I'm a salesman and I like to kind of free will on everything. But when I do sit down and take the time to put out a plan, it really helps me understand the future better. I'll do projections and stuff, and it really makes me feel better every time, even though sometimes it's a hard truth. Yeah, you're going to die. What's going to happen when you die? But once you get it squared away, you're kind of okay,
Yeah, I mean, we're all headed there eventually. But the one thing that you can say when you have a plan in place is yes, you can't avoid that outcome, but you can avoid leaving a big giant mess for other people to clean up. And, you can feel really good about knowing that although that's unavoidable, what is not unavoidable is being disorganized and having a mystery. Don't leave a scavenger hunt for your heirs. Put everything together into a nice, tidy binder, well organized, keep them in the loop, keep it updated. You won't be here to receive the thanks, but they will be thanking you. I promise.
Yeah, I have 2 clients right now that are going through issues with dementia with their partners. And, it's a lot messier once you're in a contract. Once you're in an escrow or something like that, it's a lot to fix this. So I really appreciate you taking the time.
Absolutely.
And we've got your information down below. If people aren't able to get it, you can always reach out to us, Barry@brokerberry.com. And I'll be able to connect you guys as well if you have any questions. Again, my message throughout all of this, and I think Megan would agree, is, dear God, if you own real estate, put it in a trust. That's all there is to it. There's no other thing that there's not one other thing that every single estate planner that I've ever talked to has said these same words. They've all said, if you're in California, if you're in a state with probate, you absolutely should have your property in a trust.
Yep. No excuse.
I'll tell you a dirty little secret though. I don't have a trust. I have multiple properties. So I do understand why people delay it. So if you're out there, don't be like Barry. Don't delay it. And Barry is going to make a commitment to get his property in a trust within the year 2023.
All right, Barry, get it done. We'll hold you to it. I appreciate the invitation. Thanks for including me.
All right. Have a great day.
You too.
Bye-bye.